So I will be on here just trying to make sure that the webinar goes smoothly for you. I do want to remind you guys that if you have questions during the presentation, there's a lot for Jen to go over. Obviously, we have COVID stuff. We've got new HR regulations outside of COVID as well. So if you have questions, please put them in the question and answer. Those will be answered at the end. We're going to do our best to keep this. The goal is within 2 hours. So Jen's going to be talking fast, and we're going to get to as many of your questions as we can. For those that have very specific questions, then we'll probably reach out to you individually if they pertain very specifically to your business. So make sure you put those in the Q&A section and not in the chat. I will do my best to watch both, but please keep your questions in the Q&A. All praise for Jen and her presentation can go in the chat. We are going to be sending out the slides to everyone at the end of the presentation. And so if you don't get those from me today, just feel free to reach out and email me. I'll put my email in the chat and I'll make sure that you get to those, but they're going to go out to all of the emails that were registered. So with no further ado, I'm going to introduce our two partners in this. So if you guys are not aware, we have Todd Jones, who is CEO, President of Shasta EDC, CEO or President, you pick? President.
Yes.
Okay, and we have Jake Mangus, who is CEO, President of Chamber. So
that's correct.
One of those, right? Everyone gets to pick your own title day. And O2 Employment Services has had really long-standing relationships with both the Chamber and Shasta EDC. All three of these organizations just work really hard to support the business community, which is why we present these webinars to you guys on a fairly regular basis as needed, and are making sure that it's free of charge to you so that all businesses are protected, covered, know what's going on, can get their questions answered. And so Todd, I'm going to go ahead and let you introduce a little bit about Shasta EDC.
All right, great. Thanks, Michelle. And great to be here. I'll go very quickly because I know the bulk of the content it's a lot of information. So as Michelle said, my name is Todd Jones. I'm the president of the Shasta Economic Development Corporation. And for those that might not be familiar with me, I'll kind of give a quick overview of what we do. And I'm really excited to partner with O2 Employment Services and have them as an investor. And our investors are very strategic. We like to think of them as really partners, and specifically O2 Employment Services with what they do in this information like this that they're providing. So the EDC, we basically do 4 things, and Jake will probably mention is 3 C's. So I'm trying to work on my slogan, my tagline. So we basically do business recruitment, business retention and expansion, and we do a lot of that in partnership with the Chamber. We do airline services, so we're supporting the LAX flight, which returns on March 4th. Officially, United confirmed again with us yesterday. And we help support scalable startups that are looking for investment, equity, things like that, that can have a potential for high growth and some exit down the road. So in the business recruitment world, we work with the County of Shasta, the City of Redding, Shasta Lake, and Anderson on getting businesses to relocate here, expand here, or start something new. So as Michelle mentioned, for those that were on the call at the very, very beginning, Stillwater Business Park, of course, is a big focus of ours. We have a few companies in escrow, one that closed yesterday, and a few more coming down the pipe in the next month. So we're very excited about that. And what we really are here to do is just to kind of be that strategic entity that helps align a lot of these things that are going on. And a lot of the times that stuff goes without being seen all the time. So it's great to be on a call like this and with O2 and the Chamber to really just help our businesses here locally, which, you know, for some, and I know I can see some on the call, 2020 was actually a great year. And for others, it's been really the worst year of their life. So we completely recognize that. And although we have a lot of challenges in California, and I'll stop here, I promise, you know, we still are a very vibrant economy. We're the #1 gross domestic producing state in the country. Our manufacturers are 11% more profitable than any other state in the country. And so although we have a lot of challenges, we have a lot of great opportunities and strengths. And being in Shasta County, as we all know, has doubles those strengths because we can be close to these dense markets and opportunities, but far enough away to stay out of some of the chaos that happens in the Bay Area. So again, I'm excited to be here, and thanks for having me, O2.
All right, Jake, you're up.
Well, thanks, Michelle, and great job, Todd. Todd serves on the board of directors for the Chamber of Commerce, and so does Heidi Corrigan of O2 Employment Services. So it's a great relationship we have. Thank you to O2, as Todd mentioned, for being such a strong partner in support of the business community, the Shasta EDC and the Chamber of Commerce. Yeah, the Chamber, the 3 C's, Todd, okay, I'm gonna do it. We are a convener of leaders and influencers that gets things done. We are a catalyst for business growth and also a champion for a stronger community. One of the things that was important to us back in March when the pandemic started was that we faced this pandemic head on behalf of our core audience and our customer base, which would be the members and non-members alike of our business community. We formed the Rapid Recovery Program. One of the highlights of that was bringing together partners like those that you see before you today, as well as helping to secure more than $4.5 million in business grants for businesses throughout Shasta County in need by working with the cities of Redding, Anderson, Shasta Lake, as well as the County of Shasta. And we were able to administer those programs efficiently and effectively and get the funds to the businesses to help them survive. As Todd alluded to, that K-shaped recovery, those that are doing well, we applaud them and we're grateful for their success. Those that are not doing as well, that's where our focus needs to be. So another thing that we have done is to help to provide resources such as those that you're going to hear from in a moment from Jennifer Thomas and O2 Employment Services. So we're pleased to be here and be a part of this partnership. Thank you.
Awesome. Okay, so I now get the pleasure of introducing Jen. As you guys, for those of you that know me, you know I hate bios, so I kind of always create my own. However, I have one in front of me I'm supposed to read. So Jennifer Thomas, Director of Operations and Insurance Services for O2 Employment Services. She's been with us since 2014. She is certified in HR, and that's where I'm going to stop with her bio because basically she's just like incredibly overqualified for what she's doing. She is an amazing HR rep and representative for our company. She's incredibly knowledgeable. Like the rest of our team, she has put in hours and hours and hours. Like there was no one watching the Tiger King in our office in 2020. She is incredibly dedicated to her job, to her clients, and to this community. Her knowledge is just, I mean, she's the person that I run to, right? There's a reason why I'm introducing her. So she's the person I run to with all of my questions, all of my problems, business and personal. So, but she knows this stuff inside and out. She's spent hours educating herself, reading legislation, making sure that we're current, making sure that our clients are covered and protected. And I am thrilled that we're able to share her expertise and her knowledge with you guys as well. So that is my version of her biography. I'm going to turn it over to her now. Just a reminder, put your questions in the Q&A. A lot to cover. She's going to talk fast. So I encourage you guys to stay on through the end and through all the questions because those are very informative as well. So with that, Jen, it is all you.
Well, thank you so much. Welcome, everybody. We're super excited to be here today. Thank you, Redding Chamber of Commerce, as well as Shasta EDC. Like everybody has already said, it takes a village and it takes a community to pull together, especially in these difficult times, making sure that we all come out on the other side, right? 2020 was a crazy year, and I'm telling you, from a legal update and an ever-changing landscape of business, it was unlike anything we've ever seen. I felt like I was cramming all over again for my, certification, because I'm telling you, the legislation changed daily, minute by minute, and it's a lot to keep up with. One of the beautiful things is our CEO, Heidi Corrigan, was really instrumental in making sure that we gave out all the information, whether you were a client or not of ours, to everybody in the community. We want to do our best to make sure the information is out there, making sure that everybody is educated or as up to date as we possibly can. I know we did several different presentations throughout the year, all free of charge. We wanted to make sure the information got out to you guys as quickly as possible, because I'm telling you what, between HR, CPAs, between tax law, between tax credits, between COVID, between forms, medical certifications, all of the above, there's a lot to keep up with. So we're super excited to be here today. I love doing these presentations. I don't like doing them in this format only because I can't see you. I love seeing people and I get the feeling from everybody in the audience. So I don't know if you're glazed over, if you're tracking, or if I'm going too fast or too slow. So bear with me today. I have a lot to cover and we're gonna go through as much as we can. Like Michelle said, we're gonna kind of wait till the end to do any question and answers. So make sure you put your questions in the Q&A field. So thank you for having us here today. I'm going to go ahead and get started because I've got 60 something slides to roll through. As you know, I'm not an attorney. We have a team here at O2 Employment Services that work closely together. And as Michelle said, we couldn't do it without each other. Because of all the legislative changes, it's definitely taken a toll, and there's been a lot of updates that constantly are coming in. However, we always recommend that you check with legal counsel, especially for your specific business, because you might have some nuances that we don't necessarily know. So as always, this is just guidance. And these are to be some thought-provoking conversations within your organization about how you might implement change and what things might affect you, which most of it will, and how to move forward into 2021. All right, so today's webinar format, we're going to send the slides at the very end to all the registered attendees so that you'll have them as a reference guide so that you can go back. There's a lot of links. I posted a lot of links in the presentation just so that you have some resources and tools, especially with the Cal OSHA, the DFEH. There's a lot of links in there that you guys could find helpful in your business. Everybody's going to be muted. So again, go to your Q&A field and answer any questions. And if you have any technical difficulties during the presentation, you can always call us. You can ask for Michelle or send her a little chat or a message, and we'll go from there and we'll get you all dialed in. All right, so today's agenda. First and foremost, we're going to talk about COVID-19. I know it's the hot topic and everybody is affected. And there are lots of changes that have come down the pike as far as, FFCRA, the leave pay and Cal OSHA regulations and the workers' comp presumption. We're going to discuss all of that today. We're going to talk about the leave of absence. This probably didn't affect a lot of employers in 2020, but in 2021, it's going to probably change your world. If you have 5 or more employees, you're affected. So we're going to talk a little bit about that and what that looks like for your business. We're going to do some housekeeping. We're going to talk about minimum wage and some of the mileage reimbursement changes, some wage and hour information. I'm going to go over a few case laws and a couple of things to keep on the horizon, just because it will affect the way your employees might be paid and how you're calculating some overtime situations and so forth. So we're going to go through that. We're also going to talk about harassment, discrimination, and retaliation. As everybody knows, sexual harassment is now required training as of 2021. That is one thing that did not go away with everything else. It had been delayed for several years, but this year it is in effect. So I'll give you some tools on what to do and how to get your employees trained. And we're going to talk a little bit about confidentiality agreements as well. For those of you that have confidentiality agreements or trade secrets, we're going to talk a little bit about that as well. All right, so talking about COVID-19. Yes, the topic everybody wants to talk about or doesn't want to talk about. I know it's been very, very crazy, but there's been some major legislation changes. So one is the FFCRA. A lot of you back in March, well, April 1st is when the FFCRA went into effect. That was a federal law that employers were required, if you had 500 or less employees, that you were required to offer pay, emergency paid sick leave to your employees. It might be for a COVID-related reason, or it could be for a FMLA, a Family Medical Leave Act, meaning that you had employees that had children that were out of school or they were affected. The pay structure is a little different on those, but it has now since expired. The good news with that is that employers are no longer required to pay it. So that's the good news. However, there's also still some benefits for your employees that you can continue to offer. We'll talk a little bit about that. Probably the biggest change is the Cal OSHA emergency temporary standard that went into effect on November 30th. This really rocked all of our worlds in a lot of ways, just because it changed some of the requirements and it made us step up some of our internal procedures within our organizations and had new requirements that are now required. So I'm going to go over those. We're also going to talk about AB 685, which is a model notice that is required to be given to anybody that has possibly been exposed on the work site. So we'll talk a little bit about that. And lastly, we're going to talk about Senate Bill 1159, which is the workers' compensation presumption. And I'm going to give you a few tools on how to do a little investigative work on your end, because there's some requirements from workers' compensation with positive COVID cases in your workplace. So we'll go over some of that as well. All right, so the FFCRA, the voluntary leave. So as I said, it sunsetted on December 31st, 2020, meaning that employers no longer were required to pay this to your employees anymore if you had 500 or less. If you had more than 500, there was a California bill that was in effect that you had to continue to pay it. However, employers can still voluntarily provide this leave for the same reasons and get the same tax credit. So the good news is when you paid this COVID leave, whether it be the emergency paid sick leave or the FMLA, either one of them, you got a tax credit of 50% off your federal taxes. So whoever handles your payroll, whoever handles, your bookkeeping stuff, you should be making sure that you've coded this correctly so that you can receive that tax credit. Super important. With that said, you can continue to get the tax credit through March 31st of 2021. While the regulation's no longer in effect, meaning it's required, you still can get the tax credit through March 31st if you still offer it to your employees. So employers can also opt to provide one type of leave, meaning emergency paid sick leave, instead of having to do the FMLA. So you don't have to do both. You can do one or the other. Typically, most employers choose the emergency paid sick leave because that's up to 80 hours. And it isn't as long-term as the FMLA because that could go on for up to 12 weeks. So most employers are like, gosh, I'll do the emergency paid sick leave because I want employees to be out of the office. I want them to stay home if they're ill, and I want to help pay for that. So with that, there's still some daily and aggregate maximum credits still apply. So there are certain credit limits of thresholds of how much are acceptable per day. So you want to make sure that your CPA, your payroll company gives you those aggregate numbers so that you make sure you don't go over thinking you're going to get the credit, but you might not qualify for it if you end up paying your employees more than. There's still a maximum of 80 hours. So there's no additional or no new bucket. So if you had an employee that took the leave back in 2020 and they still had some hours left over, you don't have to start them over January 1. That's kind of the nice thing. So you can use those hours and continue to pay it out, but you're not required to do any more than the 80 hours or up to 80 hours. So there's a whole threshold in which you need to calculate and figure out how many hours are available to your employees. And it really is a 6-month look back period. It's very cumbersome. It's very much a deal. And there's also paperwork that's required with this. And if you guys need any of that, we're happy to share what we have pulled together. There's probably a lot of notices out on the internet and the web that you can pull off as well, but it's really important that you have the documentation on file. So if an employee requests the leave, they need to complete a form and they need to let you know the reasons why. And there's 6 different reasons why. And so you need to make sure that they fill this out and that they give you the required documentation. And you'll want to keep that together. And I'd recommend that you keep it with your payroll records, because in the event that you get audited because of the tax credit, you'll have that information and those documents available to produce to the IRS in the event that they ask for them, because they want to make sure you're not just giving them the leave, that they're actually entitled to the leave. All right, and so for employers with 500 employees or more, there was a California rule that said you had to offer it. It's usually now for the food sector, it's required. And there's also certain counties. So if you're not just in Shasta County proper and you're outside in another area, you want to check your local leaves. It's kind of like sick leave. So if you're in one of the 23 other counties in the state of California, your sick leave rules are different. So that's always something fun to keep up with. All right, so the emergency OSHA COVID-19 regulation, this actually went into effect back in November. We've talked about this several times to our clients as well as the presentations that we've done. This is a OSHA regulation, and I know everybody goes, how does OSHA get involved and how can they tell us what to do? Well, they want to make sure that the employee is safe at work, so they're going to get involved. And they want to make sure that we are taking all the necessary steps to combat COVID-19 and the spread and limit the spread in the workplace. So they have said, you know, all employers are covered and employees are covered with the exception of this very narrow list, which are workplaces with a solo employee. So if you have just one employee within an organization, you're not necessarily having to follow these guidelines. Or if you have employees that work exclusively from home. So if you have teleworking employees that work from home, they're not necessarily, they don't have to, they're not covered in this. And employees that are covered by the ATD, which is the Aero Transmittable Disease Regulations, which is typically your healthcare industry. They already have to follow these strict guidelines, and they already have a lot of these, guidelines in place. So they're exempt from this ruling, meaning that they don't necessarily have to follow it because they already have strict or stricter guidelines for them. All right, with the emergency OSHA regulations, there's a breakdown of the rules. So there's multiple components to their OSHA regulation. And this took a lot of time to kind of decipher what exactly does this mean for employers and how do we get them the information that they need. So one is that all employers are required to have a COVID prevention plan, which is called the CPP. We have created one for our clients and we're willing to share those because it's pretty generic. However, there's one that I'm going to give you a link for on the OSHA website that you can actually take and you can utilize. You just have to fill in some information for your specific business. And you'd have to do that even with ours. And we have our clients do the same thing. But it's really, really, really important that you have this plan in place. It's very similar to your IIPP, which we'll talk a little bit about in a minute. It also breaks down the outbreak response. So there's requirements in the event that you have an outbreak within your workplace. There's also requirements about major outbreaks, and we'll discuss what defines an outbreak and a major outbreak. And there's also some employer provided housing and transportation. So for those employers out there that provide housing or transportation, there's some requirements for you as well. All right, I already spoke a little bit about the IIPP. How many of you know what an IIPP is? I sure hope so. If you don't, you need one. However, this is going to mirror, so the CPP is going to mirror the IIPP structure and requirements, all right? It must be in writing. So if a OSHA inspector comes in and asks for your CPP, you better be able to provide it. We recommend that you keep it separately from your IIPP because if they're asking for your CPP, you don't need to give them the whole IIPP so that they can go through the whole thing. We want to give them what they've asked for. So you want to make sure that it's in writing and you have it in a location that your employees or key employees know where it is and know what's in it, right? So you'll need to do some training. There's also a hazard and assessment and abatement survey that you have to do in there. So you have to go through kind of your business, make sure that you've surveyed, are there hazards, are there areas that you need to clean up or perfect and make sure that your employees are safe while in the workplace. It's going to require some regular review of your COVID-19 policies and protocols, including periodic inspections. So I recommend that if you go through and you revisit, some of your policies and protocols, that you update them and you make sure that your key staff and your staff are up to date on this and making sure they've been educated about it. Because there are some COVID-19 policies that you should have in place especially, this is something that's going to continue for a while and it affects the workplace, and we want to make sure that we're keeping our employees safe. There's training and instruction that come along with this. So make sure that you have a training log and that you show and you can prove the dates and times and who attended and what you covered and reviewed. There's also reporting and record keeping that also is required as well as part of this requirement. I've put in here the link for the OSHA model CPP, which is available to you. So you can just log on to the website. You can go to this link and it's going to show you the document that you can actually take and use for your own business. So again, if you don't have one, you need to make sure you have one. All right, so some of the requirements is making sure that you have any existing requirements that you've updated them. So if you have a worksite plan in place, make sure that they coexist with the new COVID-19 guidelines as well. So here are a couple of the requirements or things that you probably didn't have in your worksite plan. One is the physical distancing, right? 6 feet or less, or 6 feet or more, excuse me. So you've got 6 feet or more in physical distancing that you must have in place. Face coverings, making sure that your employees are wearing masks and making sure that you have the PPE available to them. The exclusions and return to work requirements, which is a big one. And this one's been one that's kind of changed a little bit, even since the original regulation came out. And we'll talk a little bit about an executive order that came out to make some of those changes. And the last piece is the paid leave. This is where it makes it tough for employers. And this is where we struggled and went round and round with OSHA and even our attorney when we were trying to figure out the regulations on this, because OSHA is basically saying, if it's work related, you're paying the employees. So we'll talk a little bit about this. So the physical distancing is required. Recent guidelines indicate that physical distancing is not possible, then physical barriers are required where feasible. So we've got the shields in place or the plexiglass in place. You might be in some businesses that have partitions or barriers. Face coverings are required both indoors and outdoors within 6 feet of each other. So this is for your employees, okay? So this is for both indoors and outdoors. I know this makes it a challenge, and I know that you have employees that don't want to do this, but you could be fined as a business, and you don't want OSHA coming in or getting complaints that you're not following the guidelines. So it's important to make sure that you have these provisions in place. So exclusions apply to confirmed cases in close contact. So close contact still means 6 feet for more than 15 minutes, cumulative minutes within a 24-hour period. So if you have somebody that's had close contact, meaning that they've been within 6 feet of somebody with or without a mask, 15 minutes or more, meaning not 15 minutes at one time, but 15 minutes cumulative over a 24-hour period, that's considered close contact. All right. And the return to work criteria supersedes. So this is the executive order N8420. So originally OSHA required that all close contacts be out for 14 days, regardless of the test result. So that changed a little bit. Back on December, they signed an executive order that suspended this order that basically said you can go off your local health department. This is why it's really important to also keep in touch and see what your local health department is doing. For Shasta County, they've got a great website. They've really worked hard on keeping it as up to date as possible. We work very closely with the health departments. We actually, I think Cheryl's probably, goes to lunch with our local health department representative because they become such good friends. Like they've literally had multiple conversations, and we're constantly at the forefront of trying to figure out what's best for Shasta County and what can we do to help make sure employers know what the local health department guidelines are. If you're not in Shasta County, or you're in Tehama County, or you're in Yolo County or Sacramento County, you need to check with your local health department, because that's going to dictate if you have close contacts. So these are your secondary exposures, right? some of you are going, I don't understand what a close contact is. Well, it's a secondary exposure, whether it's within the work site or it's outside the work site. So you have an employee that goes out to a party and hangs out with a friend who then tests positive. They notify you, let you know that we've got, I've been exposed to somebody with COVID. They need to be excluded from the workplace. They need to make sure that they're asymptomatic or they don't have symptoms. And right now it's 10 days for Shasta County. So they have to be excluded from the workplace. We'll get a little bit more into that about how the pay works. All right, so this is the return to work standard for symptomatic employees and asymptomatic confirmed cases. So the symptom-based approach, so this is an employee that has symptoms. So a symptomatic employee can return to work at least 10 days have passed since the symptom onset. Onset's important, not from the date tested, it's from the onset. And at least 24 hours have passed since resolution of the fever without medication. So meaning they're not taking Tylenol, they're not taking anything that's fever reducing, but they need to be completely symptom free, or their symptoms have been, completely improved. There was a conversation back in the day early on that you had to be completely symptom free. We still recommend that you try to keep everybody out as long as possible without, having any symptoms, because, it goes from 10 days, 14 days, and the incubation period. So there's still going to be possibility that we have employees come back at day 10 and they still might be symptomatic, just not really knowing that they are. An asymptomatic employee, so this is a person that's tested positive that has no symptoms, which we have seen in the workplace. They can return after 10 days have passed since the positive test. So that's actually with the test, because they're not going to have any symptoms. So we can't go back to the symptomatic approach because they don't have any symptoms. They've tested for some reason and they're positive, but they have no symptoms. You count from the day that their test was positive. Okay. I know, clear as mud. So returning to work standards for an asymptomatic close contact. All right. So the general recommendation is still 14 days, but you must exclude the 10 days from last exposure regardless of testing. So this is your secondary or somebody that's come into close contact with somebody. So they must be excluded for at least 10 days, meaning you have to keep them out of work for at least 10 days, regardless if they test or not. There is an exception, and it's a very narrow exception, which is the critical staffing shortage of healthcare. So healthcare falls under this rule. If you're part of an emergency response, such as, ambulance driver, fire department, somebody that's, police, something like that, or you're a social service worker, such as child welfare or assisted living facilities. In these cases, an employee who tests negative, they have to test negative after 5 days from exposure can return just after 7 days. It's a very limited, narrow window of who can return to work. So I caution you. I know that sometimes we want to say, well, we are, we treat healthcare people and we're in this industry. Check with your health department. They give great guidance. They'll let you know if your business falls under this category or not, so that you can make sure that you're being accurate. I know that sometimes I think other businesses are a part of a critical infrastructure. We went through critical and essential infrastructures, and that's not always the case of what I think versus what the actual regulations are. So make sure you check. Call your health department. They're very helpful. They'll map you out and put you in the right direction. So to use the 10-day exclusion period, the employee must always wear a face covering while at work, keep 6 feet away from others, and self-monitor symptoms through the 14th day of exposure. So if you're using the exception up there, those apply to you. So they have to come in, they have to wear a face mask, they have to stay 6 feet away, and they have to monitor their own symptoms. So make sure, again, check with your local health department if you have any questions or concerns with that. Like I said, they're super responsive, they're super busy, but nonetheless, leave them a message, they'll give you a call back. All right, so this is the fun part, I guess. I don't know. Still a little crazy, but this is the paid leave part. So Cal OSHA requires that an employee that's excluded from work with a confirmed case or close contact that's work related. This is where it's really, really, really important to understand, is this a work related COVID situation? Because if they are, and it is work related, then it basically says the employer shall continue and maintain an employee's earnings, seniority, and all other employee rights and benefits as if the employee had not been removed from their job. I know. It's crazy. And, you know, it just means that the employer has to still continue to pay the employee while they're off, especially if it's a work related. So we're going to get a little bit further down the road and talk about the presumption, the workers' comp presumption. I'm going to tell you why it's so important to make sure you follow that rule. Employees can, though, draw down their paid sick leave balances if permissible. Is permissible. So if you have employees that have paid sick leave, they can take down and you can draw down their paid sick leave, even though that might not cover the full 10 days that they might be required to be off. Okay. But if you can't require an employee to use their vacation or their PTO, right? Okay, and there's going to be the other piece of this that could be a workers' comp situation, which is why when I talk about the presumption, it's really important for you to understand why doing the investigative work is super important. So you need to make sure that if it's a work-related case or exposure, that you continue to pay the employee, right? I know, it's joyful. All right, so talking about a non-outbreak response. So this is the contact tracing. So it's critical to establish a timeline for assessing an outbreak, determining close contact, gather information to eliminate paid leave requirements, and rebuke the workers' compensation presumption, which will still be addressed when we talk about the Senate Bill 1159. This is exactly what I was talking about doing the investigative side. So I'm going to give you a little scenario. So when we have an employer or an employee that calls in to us and says, hey, I have tested positive. I've tested positive with COVID. I'm symptomatic or asymptomatic, doesn't matter, but they've tested positive. We instantly do what's called as an intake form. And we have this form that we've created as just an internal process that we go through and we ask the employee some questions. If it's the employer, then we get the contact information of the employee and we reach out to the employee and we say, hey, Jane Smith, where or how might have you have contacted this? Oh, well, I haven't really been anywhere in the last, 2 weeks. I have no idea. All right, well, let's break it down. So you go to work and you come home. Well, yes, but I also go to the grocery store. And oh, I also went to my granddaughter's second birthday party with 12 other people, right? Not saying it's right or wrong, but it is what it is. Okay, so we went there and we might have been exposed to 12 other people. Has anybody there came back? Well, not that I'm aware of. Okay, well, maybe you should check and see if anybody else became symptomatic while, from the 2-year-old's birthday party. Well, lo and behold, the employee ends up saying, yes, there was somebody that tested positive at the birthday party, right? Okay, so now we've established this is not something that the employee contracted at work. We can document all of this. We get the dates of the test, we get the test results, we see, where they've been, were they symptomatic, were they not symptomatic? Because with that workers' comp presumption, you still have to report it to the workers' comp carrier. Yeah, and we'll talk a little bit about that. But it helps you determine that this isn't a workers' comp related or a work related situation, meaning you're not necessarily required to pay. Okay, you might look at the CFRA if you've been doing it, and you might still continue to pay that, but it then no longer becomes a work-related situation. So it's important to do those steps. I know it's a ton of work, but it will save you in the long run. And it's really important to have all of those documents together. And if you go back to the CFRA, then the employee can fill out their request for leave. They have the documentation, they have everything there. You keep everything nice and neat together. You have it all together. All right. However, if the employee comes into work and they're positive and they don't find out for 3 days that they're positive because they're asymptomatic or something, you must offer testing to those that have worked closely with the employee. I know. So you have to make sure, it doesn't mean that people come to your work site and set up a lab, because we don't have those resources. You can send them out to get free testing, which is okay, but you have to make sure you identify the contact tracing of who that employee was exposed to. All right. So if the employee came to work and worked 3 days and then all of a sudden calls you and says, hey, I tested positive and I'm not feeling well, you have to go back 48 hours prior to, and you have to kind of say, okay, who did you work closely with? And this goes back to the 6 feet, 15 consecutive or inconsecutive minutes in the 24-hour period. Well, they worked with Sally. Oh my gosh, they worked with Bob, because Bob and them were working on a report really close together. And oh my gosh, did they have a mask on? Did they not? So then now you've got other employees that are excluded. Those now are work related, because this employee comes to work. That's why it's really important to tell your employees, if you're sick, stay home. But you need to make sure that they get the testing paid for. Or you can send them to a free site, or there's some free locations that they can go to. But remember, you must pay for their travel time and the test time, and they're reimbursed for the transportation costs. So that means mileage. So it becomes quite a process, right? And it's a lot to manage, but the employer is required to make sure that these things are in place. The other piece of it is that you must notify the close contacts and their authorized representatives within 1 business day. We're going to talk a little bit about this in AB 685. So this is the notice. There's a model notice that has to go out to employees within 24 hours of exposure. So even though that employee came to work 3 days later, you have to go back and do the contact tracing and say, Bob was exposed, Sally was exposed, and you must give them this model notice. We have some employers that have been doing it via email, so that they make sure that the employees get it in the 24-hour period of time, because it's going to be really important you make sure you do it within that time frame. They've also put it on their timekeeping system per se, or they've actually done a text message. Snail mail, it's a little challenging because it's not going to get there necessarily within the 24-hour period requirement. I just show proof that you've mailed it on a certain day, or you attempted to reach the employee. You can also notify the employee, by the phone and say, hey, you've been exposed, this is a situation, but I'm going to send you the model notice as well. It's required. You want to make sure you have that. So you want to make sure that you test close contacts. You always want to make sure that you keep the employee who tested positive identity completely confidential. I know it doesn't take necessarily rocket science when you have a small organization and, Bob's now out ill, and then you've got other people out, it kind of whittles down. You just don't want it coming from you. You don't want to say, hey, John tested positive on this date, and, you want to stay away from that. There's all kinds of confidentiality. We're talking about HIPAA. There's different rules that apply. So make sure you keep the identity confidential. So you want to investigate the exposures and address any hazards. So in the workplace, so if you know that John came to work and he'd worked there for 3 days, did you clean the area? Did you make sure that you went through your CPP and make sure that your hazard and abatement assessment was done of the work area? Did you clean everything? Did you sanitize? Do you need to sanitize the entire office? I know this has been, when we get into the major outbreaks and the outbreaks, sometimes that's a requirement. Otherwise, OSHA says, you might need to shut down. It just depends on how many employees you have test positive. But you need to make sure you investigate the area, make sure that, you're taking the proper precautions and making sure that the area is safe and clean, and that you've followed your cleaning procedures and all that good stuff. And the other piece of it is that you have to notify the health department. So again, it's really important that you do that intake form with the workers' comp piece of it, because you want to make sure that you have all the information that the health department's going to need. And they typically ask for the employee's name, and they ask for their phone number, they ask for the date of positive test. Even though they get some of this information from, the testing facilities, you still want to have all of this done. If it's a serious illness, such as the employee ends up in the hospital or there's death and it becomes work related, you need to make sure you notify Cal OSHA as well. They need to know. All right. So the emergency Cal OSHA outbreak response. So I spoke a little bit about, outbreaks and major outbreaks, and they define an outbreak as somebody that has had 3 or more confirmed COVID-19 positive cases in an exposed workplace within 14 days. So again, when you do your intake forms, I kind of jot at the top when that date started, and I kind of keep client by client. If you're a small employer, it's fairly easy to keep all your cases together. But if you have 3 or more positive employees, so say John came to work 3 days later, found out he was positive, and you've got Sally and you've got Bob, and those 2 end up positive, you've got 3 positive cases. And if it's within 14 days, then you've got an outbreak. So you have to make sure your local health department is notified. I will say with all of our clients that we've had, we haven't really seen this. We've come close, but we haven't seen this. So I think it's, a little more rare, but it does happen, so you have to make sure that you track the timelines in which these cases come in and when they became positive in the workplace. All non-outbreak steps are required, but additional requirements exist. So testing, immediately test all the employees in the exposed work site, whether they had the 15 minutes, 24 hours, 6 feet or less, everybody gets tested or is supposed to be tested. Now, I'll get into a fact of, sometimes employees don't want to be tested. You don't have to make them, but they're supposed to be provided the opportunity to have the testing. Now it says repeat the testing 1 week later. So this means you have to pay for them to go again and have another test. Continue testing at least weekly until out of the outbreak scenario. So the 14 days have passed and 3 cases have subsided. So you have to continue on that process and making sure they're tested. And again, you have to report it to the local health department. So an exposed workplace is a work location, working area, or common area used or accessed by the COVID-19 case during the high-risk period, i.e. the infectious period, which is 48 hours prior to the employee becoming symptomatic. Asymptomatic makes it a little tricky because you have to go by the test date, right? But anybody that's 48 hours prior to, you have to start doing the contact tracing. So they had lunch together. Oh, now they were at the copy machine together and they were doing a big project together. Those are things, those are considered common areas. This can include the bathrooms, hallway, break areas, and waiting areas. So it does not include any floor building where the COVID-19 cases were not present. So these are in larger organizations, and you have building A and building B. And people in building B are the ones that, might have tested positive, and you have the 3 cases. Building A doesn't need to go through all these requirements unless they had direct exposure, but otherwise you don't have to include those with the case. And this does not include areas where masked workers momentarily passed each other without interacting. So I know sometimes employees get really nervous and they're like, oh my gosh, but I walked past, John's office and, I waved at him, and, that's not considered an exposure, unless they spent the 15 minutes together in a close, less than 6 feet space. So it's important to keep people calm down. I know it's tough and people get a little worried, especially when they have older family members at home and so forth. We fall into this category a lot with a lot of our employers, and it makes it hard. So one of the ways that you can, prevent some of these, outbreaks is to use cohorts to prevent triggering an outbreak, meaning this can limit the number of people that are in an exposed workplace. So a lot of people call these bubbles, or they have staggered work shifts. so that they come in and work at different times. So you limit the amount of exposure that you have. This works great if you're in a large organization and you can operate at different hours, and it's fine to, you know, have 4 people come in at this time and 4 more people come in at this time. It doesn't work so well when you're a small business and you rely on every single person in the business, right? And that's where it makes it difficult. So that's where your PPE is really important. So same is true for overlapping shifts in one facility. Each shift can be considered its own exposed workplace for purposes of counting the cases to assess the outbreak. So if you do have these bubbles or pods of people, that's your exposed area versus the entire organization, which is helpful if you have a larger organization, right? So if you have these smaller pods of employees that work together, then that's your exposed group. You're not doing the entire organization, which is helpful. The facility must also have a well ventilated and must be cleaned and disinfect between each shift. I know that makes it a challenge as well. So you must make sure that you're following the guidelines and making sure that you're, you know, the shift is, you know, the areas, the work areas are cleaned, and it must be well ventilated and making sure that people are cleaning. You know, we have Lysol wipes all over the place. We shower down our desks every night before we go home. You know, it's just important to make sure, because we just don't know, you know, especially with asymptomatic employees. All right, so I'll talk a little bit about a major outbreak. In a major outbreak, I'm going to say we thank heavens haven't seen this. We don't have very many large employers that have this, but a major outbreak is 20 or more confirmed COVID-19 cases in an exposed workplace in 30 days. So it's 30 days, 20 or more. That's considered a major outbreak. Of course, the all outbreak steps are required, but there's additional requirements exist. So the testing is now bumped up to 2 times a week. Change the ventilation and filtration system, or making sure that it's cleaned, assess the need for HEPA, air filtration units in poorly ventilated areas, determine if there's need for a respiratory protection program. And sometimes they'll make you consider shutting down because it's considered a major outbreak. Again, you need to make sure that if you have 20 or more cases within 30 days, again, you'll want to do your intake forms and kind of count how many you have. So, you know, it's important to make sure you track that. Talk a little bit about housing and transportation for those employers who provide housing. So such as camps, hotels, motel rooms, living quarters. You need to make sure you're ensuring that there's enough space for employees. And if you send them out of town in hotels and you're bunking together, you know, be mindful of that. It also applies to transportation provided or secured by the employer. So if you're carpooling and making employees carpool together, take buses or shuttles, those are also areas that you need to make sure you provide these things to. So ensure that there's enough space for physical distancing, 6 feet apart in a housing unit or vehicle. Well, I don't know about you, but I'm not sure what vehicle I've been in that provides 6 feet of space, unless you're in a bus. And then, you know, maybe you do one and then 6 rows back, you do another, I don't know. Providing face coverings to all employees, you should make sure they have those. Ensure that there's sufficient cleaning and disinfecting, meaning living quarters, kitchens, bathrooms, common areas must be cleaned and disinfected at least once a day. All high contact surfaces and vehicles must be disinfected before each trip. So if you have 2 employees that carpool together, make sure you're doing the cleaning precautions, they're wearing their face coverings, and, you know, just do the best you can. All right, I know that's a lot of information and everybody's eyes are probably spinning and glazed over. I know mine are, because every time I talk about it, I think, oh my gosh, you know, it's so much for employers. All right, but we're going to move on to AB 685. So this is the workplace exposure notice. I spoke a little bit about this earlier, and I talked about that you're required to give it to employees that have direct exposure within 24 hours. So it must be a written notice, and it's provided to all employees who were present at the work site during the infectious period. Again, I usually take the date of when the employee tells me they became symptomatic, and I go back 48 hours prior to and see who they were with, who they worked closely with, and go through all of those steps so that I can make sure that I recognize them. This also includes subcontracted employees. Okay, so this makes it even more challenging, right? So you have independent contractors, or you have other vendors, right, that you're working with. So you have a sales associate that comes in and sits down with the employee and meets with them. They're exposed potentially if they spent more than 15 minutes with the employee, not even consecutively, but within that time period. You also have to make sure that you notify them as well. So outside vendors, independent contractors, and bargaining unit representatives as well. In the event that you're part of a union, you need to make sure that they're aware. So the notice must include the following. So the potential exposure to COVID-19 in the workplace, information about COVID-19 related benefits, okay? The employer's disinfection and safety plan that is in place, and an anti-retaliation and anti-discrimination protections for the employee, okay? So all of those components must be in this model notice. So I recommend you go out and you look for your model notice. Cal OSHA has one that you can get offline that you can do fillable and put in your specific business information. We have one as well. If you want it, reach out to us. We'll share with you what we have. The written notice must be sent in a manner to the employer the employer normally uses to communicate employment related information. Is it in person? Is it email? Is it text message? It must be designed so that it's reasonably anticipated that the employee will receive the notice within 1 business day of sending. So this is where it's important, if you're going to use snail mail, that is it going to get there within 1 day? The notice must be in both English and the language understood by the majority of your employees, right? So it's kind of like your labor law poster. It has to be in the language in which majority of your employees speak. One of the things that is out there is they're talking about PAGA lawsuits. And I know I don't want to confuse you even more, but there's a PAGA situation that could come up in the event, meaning there could be a class action lawsuit in the event that employers don't provide this to employees. It's kind of like COBRA, right? So if you have COBRA, and you offer health insurance, you have a requirement to make sure that the employee receives initial COBRA information, and once they're terminated or they've left the company, that they have the right to continue their health coverage. Well, this notice follows the same suit, and there are attorneys out there that are looking, saying, did you get your model notice within the 24-hour time period? And did it have these requirements in it? Saying, make sure you do it, because you don't want to be part of that you didn't end up getting the notice out to the employees in the time frame. All right. So there's a separate requirement to notify local health department within 48 hours of an outbreak occurs. So this is consistent with the Cal OSHA regulations and the pre-existing reporting requirements. So if you're already following the other, you're going to make sure that this is taken care of. Although then an outbreak is defined by the California Department of Health, which specifies the individuals be from different households. You know, it's a little different requirement, but we're always going to go with the more strict. I mean, sometimes you'd make yourself crazy by following all these different guidelines. We just want to make sure you follow the strictest, and it's California compliant. Exemptions from the notice requirement are employees whose regular duties include COVID-19 testing, or who provide patient care for known or suspected COVID-19 cases, unless the qualifying individual is also an employee of the same worksite. Healthcare facilities are exempt from the outbreak notice requirements as well. Okay, so there's a few minor exceptions that are out there that don't have to be provided the model notice. Okay, moving on to the Senate Bill 1159. Again, this went back into effect many months ago. And I think it was back in July that actually it had changed, and it said, you know, there's a presumption out there that every positive case is workers' comp. And everybody went, oh my God, what do you mean every case is workers' comp? Because that's going to kill us. We can't say that. So that's why we said, okay, we have to go after every positive case within our organization and be a little investigative and figure out how the employee contracted it. It very well could be work related, and sometimes that happens, but it's also really important that you know that you must notify your workers' comp carrier for all positive cases. Your workers' comp carrier, if you haven't done this already, you need to reach out to them and say, what do you need from me in the event that I have a positive case within the organization? They're going to say, we want some very basic information. It doesn't mean that they're going to file a claim, but it also gives a heads up to the workers' comp carrier that they know that there's been a positive case within the business. So this extends, though, the workers' compensation presumption to December 31st, 2022, but only for certain first responder employees. So this is healthcare and health facility workers. So they have a little bit longer in the event that they want to go back and file a workers' comp claim, they have a little bit longer to do so. For other employees, workers' compensation presumption will only apply if COVID-19 diagnosis occurred during an outbreak at the employee's specific workplace. All right, the presumption can be rebutted if the employer provides evidence that the employee contracted COVID-19 outside the workplace. Again, I can't impress upon you guys enough that doing an intake form or doing some kind of investigative work at the beginning when the employee tests positive of trying to figure out how they contracted it. It's not to be invasive. It's not to be, I need to know your life history, but we also have to figure out, was this work related or not? Because it also determines whether the employer has to pay or not. So make sure you do the initial legwork. I know it's a lot of work. I know. But it's really important that you do. The definition of an outbreak depends on the employer's size and the number of employees. So the workers' comp presumption is a little different than back in the OSHA outbreak definition. So their guidelines are for a workplace of 100 or fewer employees, 4 or more confirmed cases within a 14-day period. Okay, so if you go back to the OSHA regulation, it's 3. So you either have a workers' comp that you have to notify if you've got 4, OSHA, and your health department if you've got 3. If you've got over 101 employees in the workplace, it's 4% or more of the employees have a confirmed case within a 14-day period. Also, you want to make sure you look at your health department as well as your OSHA orders in the workplace if you need to close. So make sure you follow up on that. And, reach out to your health department and make sure if you've got 4 or more cases, there could be some potential that you might have to close down. So employers must report confirmed cases to their workers' compensation administrator within 3 days. So if you haven't been reporting your positive cases, you have 3 days to do it from the date that you're aware. The administrator, not the employer, determines whether an outbreak has occurred. So that's one thing that's kind of taken off your plate. You notify the administrator of your workers' compensation carrier, and they're going to determine if an outbreak has occurred. It doesn't mean you don't avoid calling them and telling them what's going on. I know. We all try. All right, so vaccine. I know this has been a hot topic, especially from an HR standpoint, because employers are like, I want to make sure my employees are vaccinated. And, there's a lot of news out there and everybody's talking about the vaccines. And obviously we have specific tiers that we're in and who can get it first and, which employers can get it first and so forth. So there's the vaccines are in progress. We've got the phase 1A, which is the actual progress varies by county. So every county is a little different. So shastaready.org has the list of who is eligible first. That can go. Usually it's the healthcare workers and long-term care residents that are eligible first. We've started to see maybe some of the 65 and over. If you go and do the clinics, they're allowing first come, first serve. I know that Shasta Regional is going to start doing this. I think they actually start today, maybe tomorrow, Wednesdays. They're going to be doing a clinic, but it's first come, first serve. And you have to kind of go and sit in line and wait for them, but they're doing them outside of some of these requirements. But the next phase is the 1B, which is risk of workplace exposure in sectors such as education, childcare, emergency services, food and agriculture, transportation and logistics, industrial, commercial, residential, sheltering services, and critical manufacturing. So that will be the next phase. So I know a lot of employers want to make it mandated that employees get the COVID vaccine, but there's some pitfalls with that. Because there's some employees that can't get it, right? Could be a disability, there could be a medical or a religious accommodation. So you can't terminate them in the event that they can't get the vaccine. So why would you make it mandatory? I think it's, if you want to recommend it and that maybe you'll pay for it if they want to do it, you can walk down that road. Again, check with legal counsel. This has been a hot topic and something that's very much changing landscape. So there's a lot of permissive programs to avoid the majority of those issues. Whether required or not, vaccinated employees are not exempt from the requirements to physically distance and wear face coverings. All current safety precautions still apply. All right. So if you go and get the vaccine, it doesn't mean that you don't have to follow, your CPP outline or your guidelines. You still have to do the training. You still have to wear masks. You still have to have the partitions up and so forth. There's some EEOC guidance available. I've included that link for you. In the event that you're thinking about making this a mandatory thing, you want to make sure that you're following the guidelines and the rules. All right. Okay. Now that I've just completely wowed your socks off and you're thinking, how in the heck am I going to do all of this? We're going to talk about leaves. Yay. I know everybody's so excited. I can honestly tell you, we are probably the least excited about this, and I'm sure you will be as soon as you hear more about it, because it definitely changes the landscape within some of your organizations. Back in the day, it used to be just employers that had 50 or more employees had to follow the leave laws and the guidelines and the leave requests and serious health conditions and medical needs and all of that. Well, California Family Rights Act, which is also known as CFRA, has changed the requirements. Okay. So it used to be 25 or more employees used to fall under CFRA, and we still, teetered back and forth with this, and there were a few exemptions with this. It also talked about, what qualified as a leave and what you had to do from an employer standpoint. So right now it says the California laws changed as of January 1 that provides 12 weeks of job protected leave during a 12-month period for eligible employees with certain qualifying reasons. So eligible employees, they must have been employed with you for at least 1 year. That's part of the qualifying process. And they worked at least 1,250 hours the preceding year of request. So making sure that you go back and you have to check and see if they actually meet that hours requirement. The qualifying reasons are to care for one's own serious health condition, care for a family member's serious health condition, bonding for birth of a child or placement of a child through foster care or adoption. These leaves can currently run with workers' compensation leave. So if you have an employee that goes out on workers' compensation, you'll want to make sure and see if they qualify for this as well, because you can run these simultaneously at the same time. And it's important to do so, because if an employee comes back later and you didn't qualify them for the CFRA leave, then they could potentially have more time off. It becomes a very sticky wicket. Same with the FMLA. So if you're an employer with 50 or more, this leave also applies, and there's some different changes in it. So you want to make sure that you understand it, because the employee can stack some stuff. So we'll talk a little bit about that. Healthcare benefits must be maintained during the leave under FEMLA, CFRA, and PDL. So the employee has to continue with the same health benefits. So you have to continue paying their health coverage if they qualify for the leave. So with the expansion, it applies to the private sector of employers with 5 or more employees. This was previously the 50 or more employees. It also eliminated the requirement of eligible employees work at a work site of 50 or more within a 75-mile radius. So if you had businesses that were more than 75 miles away, then you didn't necessarily fall under that. Well, this is eliminated, so you don't even have to worry about it. If you have 5 or more employees, you're eligible. All right, and if you're in the public sector, regardless of the number of employees, you know, you're going to be eligible to make sure you track this. I can't impress upon you enough. Leaves are probably my least favorite thing to do, and thank heavens we have specialists. We have Terry and Sean here in our organization that do these all the time. Thank you, sweet baby Jesus, because I'm telling you, they're a lot of work. So if you don't have somebody that's in charge of this, your first item of business, you need to make sure somebody's in charge of this within your organization. And know that if they come to you and say, I've got a health condition, or, you know, there's a couple other caveats, or I'm pregnant, or I'm taking leave, that you start tracking this and see if they're eligible, because there's required documents you have to give them. All right, I'm going to keep rolling along because I know I'm limited on time. So a covered family member with a serious health condition. So this is a child, parent, spouse, or registered domestic partner. So the expansion of this bill also includes grandparent, grandchild, or sibling. So it can be one of those, okay, which not necessarily are involved in the FMLA process, which means that the employee could stack both if you're over 50 employees. It also eliminates the restriction on taking the leave to care for an adult child with a serious health condition. It also qualifies exigency family military leave, such as CFRA qualifying leave, which generally mirrors the similar FMLA qualifying leave. If you have military leaves, call us. We'll try to help walk you through that. So the leave entitlement began January 1 and will depend on the hours worked in the previous year. But if you had an employee that was out on PDL, which is pregnancy disability leave, in the prior year, so in 2020, the 1-year look back period begins prior to the start of the PDL. So if you had somebody that went out last November, December, you want to do a look back to see if they were eligible, because now we're in January, and so some of these leaves apply to them. All right, there's also, in this expansion, it also eliminated the ability for employers to employ both parents of a child to limit bonding leave to a collective 12 weeks for both. This is a big change. So this is something, if you have a husband and a wife, or you have partners that live together and have a child together, they're both entitled to 12 weeks, which means you have both employees out, one for 12 and the other out for 12, and they don't have to take them at the same time. So each parent who works for the same employer is now entitled to a 12-week for bonding leave. It eliminates the key employee exception to the right of reinstatement upon return from the CFRA leave. So it used to be if you were a key employee, you had some reinstatement rights. That's been eliminated. It creates more deviation from FMLA leave, creating the potential for the employees to get 24 weeks of protected leave off. That's half a year. So leaves, super important, and you need to make sure that you understand it. There's also posting requirements, okay? So make sure that your posters are up to date, making sure that you have them posted in the break room, making sure that you have somebody within your organization that understands enough to make sure that they get them the required documents. They're super important. They're going to save your bacon in the long run. The DFEH has actually put out some really cool toolkits, and I mean, as cool as the DFEH can be, but it helps employers and employees also go through what they're entitled. Okay, so I also said employees. So your employees can go out and they can find this information. So if you as an employer aren't following this, they might come to you and say, I'm entitled to 12 weeks of time off. Mind you, it's not paid. You don't have to pay as the employer, but you have to entitle the employee the time off, and it's protected. I've put some links in here so that you guys can go to the DFEH website. There's some interactive toolkits. I went through these last week. I was on a labor law call as well, and they went through this. The DFEH was there. It was actually super cool. All right, I'm going to quickly roll through some of these things because, you know, I get to yapping away and lose track of time. And I know you guys are thinking, oh my gosh, is this ever going to end? But AB 2017, which amended the Labor Code 233, which is kin care. All right, so kin care has been in effect for a long time, whether you knew it or not. It provides employees the ability to use 1/2 of their annual sick leave accrual for the following reasons. Okay, so diagnosis, care, treatment of a health condition or preventative care of an employee, diagnosis, care, or treatment of a health condition or preventative care of an employee's family member, parent, parent-in-law, child, spouse, domestic registered partner, grandparent, grandchild, or sibling, or for purposes related to the victims of domestic violence, sexual assault, or stalking. That's a special labor code. And there's also requirements in your new hire paperwork that you have to make sure you give them that information. AB 2017 gives employees the sole discretion to designate at the specific basis used for the sick leave under this provision. So if they say that it's for this child and for kin care and they want to use it, you need to make sure you give it to them. Obviously, they have to have it. The crimes victim leaves prohibits retaliation against an employee for taking time off for matters related to sexual assault, stalking, domestic violence, and reasonable accommodation for such individuals' workplace safety. So this is expanded to include victims of crime that cause physical or mental injury and threat of physical injury, and 2, persons whose immediate family members is deceased because of the crime. So there's some leaves that are allowed for employees to do that, and there's no retaliation against the employee for that. Again, make sure you've got your most recent up-to-date victim leave paperwork that should go in your new hire paperwork. Immediate family members are defined as, regardless of age, a biological, adoptive, foster child, or child of whom an employee stands in loca parentis, biological, adoptive, foster parent, step parent, legal guardian of employee and their spouse or registered domestic partner, spouses or registered domestic partner, biological, foster, or adoptive sibling, step sibling, half sibling, and other individuals who have close association is equivalent. You can ask for documentation for this, including a written statement signed by the employee. All right, moving on to some housekeeping items. Most of you already know this, and I probably sound like a broken record because every year I talk about minimum wage increase. So January 1, minimum wage increased. Okay, we're at $14 for employers with 26 or more. 25 or fewer at $13 an hour. In January 2022, we're moving up to 15 and 14. By 2023, we're all going to be across the board at 15 bucks an hour. However, if you're in other counties outside of Shasta County, such as the Bay Area or Southern California, make sure you check those local minimum wage increases because they're all different. Just like the sick leave laws, make sure you're up to date on those. Even if you have employees that go into San Francisco and they work for 2 hours or more, there's sick leave law requirements. I know, I don't make this stuff up. Based on salary updates for exempt employees, okay, so under the California wage order, you have to pay at least 2 times the state minimum wage for exempt employees, all right? So if you have small employers with 25 or fewer, you're paying $54,080 per year. And if you have larger employers with 26 or more, the minimum requirements are $58,240. Computer software employee exemptions increased to $47.78 per hour, or an equivalent per month and per year. You also have to have the exemption notice to qualify. So there's an exemption notice that you can go through that kind of breaks down, is my employee exempt or not? Just because you say they're exempt doesn't mean they necessarily meet the requirements. And just because you pay them that much doesn't mean they're exempt from overtime. Okay, that's what I mean when I'm talking about an exempt employee. They're exempt from overtime. All right, minimum mileage reimbursement rate. So we got a little break. We went down to 56 cents per mile. It reduced from the 57.5 cents per mile. So keep that in mind, especially if you're sending employees to be tested for COVID, or they're traveling for the business, or they're teleworking. We'll get to that in a minute. That mileage rate has changed. AB 1963. So this is also if you have employees that are under the age of 18. Okay, so if you have employees, I always say if you have employees that are operating on a work permit, there's now a mandated reporter training that must be taken by individuals that supervise the employees. All right, so it's called the mandated reporter training, and it's regarding sexual abuse and human resources. We've all taken it, you know, it's only required once, which doesn't necessarily make sense to me. I would say that, you know, you should probably do it every couple years because I think it's a good thing for people to refresh. If you have new supervisors coming on board, you probably should make sure they do that as well. But it's any employer that employs minors. You want to make sure that you do the training. I have given you a link here with the general training. The Department of Social Services offers this training. I believe it's free. You can go on there and do that. Some other, you know, I think you can pay for mandated training reporting out there, you know, through the chamber or some other places as well. And the employers are required to provide the mandated training to the employee, okay? And if it's mandated, that means it's paid time, all right? You're paying the employee for the training. All right, I'm briefly gonna go over settlement agreements. These are severance agreements and making sure that you've removed the no hire clause from them. So back in the day in severance agreements, you basically say, here's your severance, here's your money, and I'm not gonna rehire you ever again. You need to remove that. The exception is if it's sexual assault or harassment. And if that's the case, there should be one that, you know, your attorney can draft up for you. There's probably 2 different versions you can have. Make sure you just have your legal counsel look at them. Some of that's been taken out and you want to make sure you're up to date with those. So have your severance agreements taken a look at by your legal counsel. I know I'm ripping through this stuff, you guys, but I've been given the red light. I got to move. All right, COVID-19 wage and hour considerations. So this is important because we have a lot of employees that are teleworking these days. Expense reimbursement requirements. I know that, you know, you're trying to keep your businesses open and you want employees to work remotely because it's safer for them to stay home. They can still manage their day-to-day operations. You know, and their workload, they're getting stuff done. Hopefully, you know, I know this is hard and we've done a lot of different, you know, webinars and conversations regarding how do you monitor them from working from home, but that's a whole nother topic and discussion for another day. But making sure that you're reimbursing for employees working from home. This means their cell phones and their internet. Make sure that you're providing paper, printer cartridges, that kind of stuff while working from home. Reinforce the obligations for employees to track hours and taking their meal and rest periods, okay? You're not there to police this. You need to make sure you remind your employees. You have to still, especially if you're a non-exempt employee, meaning you're an hourly employee, that they're working during 8 to 5 or whatever time schedule you have them committed to, that they're still taking their rest breaks and they're still taking their meal periods. All right, it's really important because you don't want to end up in that wage and hour situation where they're not being provided an opportunity, even though they're working from home in their pajamas and, you know, teaching their kids still. You still want to make sure that that's being afforded to them. Also make sure that your employees, non-exempt employees, aren't answering emails at midnight and 1 o'clock, and are you paying them for that time? All right. It also is important if you have them come and pick up supplies, that those are compensable hours and mileage reimbursement is applicable. All right. I really encourage you guys to use teleworking agreements. I think they're really imperative and it sets a very clear expectation of what you want your employees to do from home and what's appropriate and what's not, especially from the workers' comp side of things, to outlining an expectation of what you expect from them, as well as clearly putting it in writing. Okay, because you might need that writing someday and come back and say, well, you signed an agreement on this date and this is what we covered in it. And if you had any questions, you should ask. But there was an opinion letter that was updated by the US Department of Labor. So an employee who chooses to telework for part of the day and work in the office part of the day with sufficient time to perform personal tasks in between, then it's saying travel time is not compensable, meaning the commute time doesn't have to. An example means that an employee performs work at home, but goes to the doctor and then comes to the office or vice versa. You don't have to pay that time. All right. So making sure that you understand when you have to pay an employee for traveling to and from work, you know, especially if you're having them pick up supplies or versus whether they're choosing to work from home and they want to get these things, you know, going to the doctor and working part day in the office and part not. Another opinion letter that was updated by the FLSA, which is about compensable hours as far as training. So the general rule is time spent in training is not necessarily compensable when the attendance is outside the normal working hours. It's one part. Attendance is in fact voluntary. Okay, the employee chose to go do this. You didn't tell them they had to, or you didn't say, oh, it'd be really nice if you did this. It's totally on their own. And the caveat is the training is not directly related to the employee's job. This is where it gets tricky, because if it's going to better your business and it's going to bring you any revenue or it's going to make the employee more valuable, you better think twice about not paying for that time. And the employee, lastly, does not have to perform any work during this training. The exception, training is directly related to the employee's job, but whereas the employer establishes a program for the employee's benefit and attendance is voluntary and outside normal working hours, even if the course is paid for by the employer, where the employee attends on their own initiative, independently course after hours. Okay, so if you have some type of agreement in place, that might fly, but again, I would check with your legal counsel. And if the employer allows voluntary attendance during regular work hours, so you say, oh, you can do it during the workday, you know, it's totally fine. Whether the training is directly related to the job or not, it constitutes as compensable hours worked. So it means you're paying the employee if you're doing it during the workday. Employers can, within parameters generally applicable for non-compensable training, prohibit attendance at such training during work days to avoid converting them to compensable hours. So the employer can say, hey, sorry, it's not going to work. You can do it after hours, you know, and you can do that. Presumably, this would not count if training is done voluntarily during the employee's off-duty meal period. Okay, so if they decided to take it during their meal period, then that might be different. All right, just a quick recap on the regular rate of pay. So under federal and state laws, certain types of compensation must be included in calculating non-exempt employees' regular rate of pay for purposes of overtime. This is something that is really important, and I think a lot of employers don't realize, but if you have a non-discretionary bonus, commissions, or production incentives, those actually factor into the regular rate of pay because you have to average all that out, and that then becomes the employee's average rate of pay for overtime purposes. So you might want to check with your bookkeeper or whoever's handling your payroll and making sure that those calculations are done correctly, especially for overtime, because there's a look back period within the pay period or whenever the bonus or commission was earned. You have to go back and calculate overtime hours appropriately. So make sure you pay attention to that. Just a quick note on referral bonuses that are not included in the regular rate of pay so if you have referral bonuses, so you have an employee that is tied to longevity of an employee that's referred, it must be included in the regular rate of pay unless A, the referring employee need not be employed when the bonus was earned, so they weren't part of the company yet, and B, it's not contractually guaranteed. So if you have a contractual agreement, you better double check that. I'm not going to go into that too much because I'm still whipping through my slides. All right, so one of the most important case laws that kind of came out this last year was Oliver versus Minolta Business Solutions. And this was about commute time and if it being compensable or not. So if you have employees that commute for your business and they're carrying tools, pay attention to this. Or they're carrying anything in their vehicle that makes it so that the employer might have control over the employee. It might be compensable time now that the employee is doing the commute time. So this is one that really needs to be watched. So if an employee were required to transport tools as parts in their personal vehicle, was the volume required a barrier to which the employee's ability to utilize their commute time for personal pursuits? So the question is Did you make them carry a bunch of stuff in their car that they couldn't pick up their kids, or they couldn't, you know, have a passenger in the car? You know, it's a little undefined, but it could constitute that you have control over the employer and you're required to pay them for that time. I know. All right, here's another one to watch. This is a very important case, and the reason being is it's going to determine the regular rate of pay for penalty payments. So this is for missed meal and rest periods. So they say, you know, they, meaning the, you know, Department of Labor and the wage orders say if an employee misses or is not afforded the opportunity to take their meal or rest period, they're either entitled 1 hour of regular rate of pay. Well, people pay it at the regular rate of pay, their hourly rate. Well, if you're doing incentives, commissions, non-discretionary bonuses, that could be included in that and bump up that regular rate of pay. And so this is a case to watch, because this is going to determine whether or not we're paying it correctly with the regular rate of pay. If they're at minimum wage $13 an hour and you're paying the premium at $13 an hour, or is it going to be with the discretionary bonus, commissions, or other incentive compensation? Is that supposed to be factored in and it bumps that wage up? So this is a case to watch. I won't go into too much detail about it. All right, harassment, discrimination, and retaliation. Whistleblower protections. So it prohibits retaliation against an employee for complaints that their employer violated the law or refusing to engage in unlawful activity. So there is zero retaliation if an employee comes out and complains about the employer, saying that they were engaging in unlawful activity. There's whistleblower protections. This is on your labor board, on your labor law poster. So if you go back and you look at your labor law poster, it's going to have whistleblower protections. But this law now amends, the Assembly Bill 1947 amends that it allows recovery fees, attorney's fees to the plaintiff. Okay, so that's huge. That's a big deal. So we want to make sure that we're not asking anybody to do anything that's not lawful. Sexual harassment, we talked a little bit about this in the beginning. It's still required. You have regular employees that are non-supervisory, and you have supervisory employees. They're required to take the training. It's 1 hour or 2 hours. It's every 2 years. You better figure out a system how to track it. You want to make sure that they're completing, in the event that they start out as an employee, they take the 1 hour and then you promote them to a supervisor position. They're then required to take the 2 hour training within 6 months of promotion. We recommend that all employees do it upon new hire. There is a free link here that I have posted through the DFEH that offers you the non-supervisory and the supervisory training. They also have it in multiple different languages. So if you need that, I'd go to that website and make sure that you get that on your onboarding process, so that you can get these employees trained right away. Then you can track it and make sure that they've completed it. We do it within the first 30 days because there's some language around temporary employees that they must be trained within the first 100 hours. Okay, that's not even a month. But we say the first 30 days, let's get them trained and ready to rock and roll. If they're a longer term employee, it's a little bit longer, but I'd rather just get it done, over with, and make sure that they have the training. You have to make sure that it has some components of making sure it's interactive, making sure that they have a certificate that you can keep on file and give the employee a copy, which you'll get at the end of this DFEH one. And make sure that you keep tracking that all your employees have had it. All right, confidentiality and trade secrets, we're almost there. So just making sure, I'm going to quickly talk about this because I know a lot of businesses have trade secrets and they have agreements that they have in place. Double check with your legal counsel, make sure they're up to date. I know that confidentiality agreements are super important because they have a lot of your trade secrets, right? And they're specific to your business. And most of the time, those are going to be okay. It's when you get into a broader scope of confidentiality that becomes maybe a problem. And this is where you might want legal counsel to take a look at your agreements and make sure that they're okay, or what risks they pose by leaving some of that language in. So an employer and employee post-termination non-compete agreements. So I know a lot of people are like, once you're no longer an employee, you can't compete, you can't have this. Talk to your attorney, because there's a very narrow exception, is when they're permissible, and it's very few. Employers and employees customer non-solicitation agreements, they're also unlawful. However, have your attorney take a look at them, and they might say, we're going to leave some of this language in, but some of it we're going to take out. The other piece is employers and employees post-termination employee non-solicitation agreements are potentially unlawful as well. Again, I really want to make sure if you guys have those, that you have your attorneys take a peek at them, because there's some language changes that could impact you, and you think you've got a leg to stand on, but you really don't. And you want to know that before you go in and make people sign things, and you think that you have a concrete, trade secrets agreement, but it's 5 years old, and some of these laws have changed. So there's further scrutiny of confidentiality agreements, the increased importance of trade secret protections. It kind of narrows it down to what's a trade secret versus what's confidential information. Remote work needs to enhance the trade secret protections program. So again, go back to your teleworking agreements, making sure that they have that information in there, because obviously you don't want your client list laying around a house and they have a house full of people over, and then your whole client list is exposed, and then you find out, but you don't have a trade secrets agreement in place. Make sure you do employee training and education. Obviously make sure you do these while you're onboarding. Usually you do the confidentiality agreement at the time of new hire, and then when you separate with the employee, you have them sign another document that says, this is what I've learned, this is what I've retained, this is what I've maybe created while I worked for you. There's an important process that you have to have the employee sign off on those as well. All right, you guys, I've probably just blown your mind, and that's all I'm going to cover today. I know it's a lot. I know we've got a few questions out there, so we'll get to those. I know Michelle's going to pop back on here, but I appreciate you guys so much, and I appreciate you guys taking the time out of your day. I know you're all busy, but you know how important this stuff is. We're here to help. Obviously, we eat, breathe, sleep this stuff. This is what we love to do. This is why we're in HR. And we're always available to try to help navigate you guys through this windy road, because I know it is treacherous, and my hat's off to you, especially these businesses that have really endured so much throughout this last year. Again, we're all in this together, and we're here for you. And any questions, feel free to shoot them in the Q&A section. We'll try to answer them as much as possible. Thank you.
Okay, so we are going to get into the question part in just a bit. I just want to remind you guys, for those of you that aren't familiar with O2 Employment Services, or that use us primarily for your staffing needs, Jen, I'm going to have you advance the slides for me. Just the one. So this gives you an idea of, if the last hour and a half did not put you to sleep, this is what our team does all day, every day, including Saturdays and Sundays, evenings, early mornings, you name it. I don't think Jen took a lunch break in all of 2020. So, but basically we are an outsourced HR company. So we are the HR department for hundreds of businesses in this community, as well as up and down the state of California, a couple in Oregon and Nevada as well. So it's a huge job, but as you guys know, it's a huge risk as well. And it's something that, if that's an area that you're interested, I know in 2020, everyone was like, take my HR, I don't want it anymore, I'm done. And so we are able to slowly bring on clients right now. We have to obviously keep that measured, but we are looking at 2021 and being able to open up more of those positions. So if it is something you're interested in, please reach out to us. We have loved providing these free services to you. It was an amazing undertaking by our company that put a massive amount of work on our employees' plate. So kudos to them. Jen, I'll have you advance it again. We are not charging for these services. However, we would absolutely love to hear about how much you love Jen and her presentation. And we would love for you to give us a 5-star review on Google. Anything less than 5 stars, just go ahead and email me and we can talk about it. But if if you have benefited from our services, benefited from our help during this time, we'd love to hear about it. So shameless plug, we need 5-star reviews. So in addition to that, I know a lot of people have reached out and messaged and asked about the free things that we have available to you. So that we are going to share our intake form. If you guys are interested in that, we do have the CPP example as well that we can share with you. We have the notice of exposure. We have the FFCRA leave forms if you're continuing to offer that. Or if you did not get those completed for leaves that you extended in 2020 and you want to make sure you have that backup, should the IRS ever ask for it, please feel free to email us and reach out. And Jen, you will be happy to know that I was able to answer most of the questions, but I saved a few of the doozies for you. So,
Awesome.
first one, is the CPP required if employees are working at home full time?
So great question. If all of your workforce is working from home, then no, the CPP is not required. It's a good idea to have in place, and especially if you're going to bring them back into the office, you want to make sure it's done so that you're prepared for this. But if all of your employees are working from home, there's those 3 narrow exceptions at the beginning. A solo workplace, everybody's teleworking, or you're part of an ATD, which is the healthcare field. So you wouldn't be required to have it.
Okay, perfect. Do you know if close contact quarantine still applies if an employee has already tested positive 1 to 3 months ago?
Right. So I believe what you're stating is that if an employee tested positive 1 to 3 months ago, do you still have to do the close contact intake form? You know, it's probably not a bad idea if you can to get the information, because the workers' comp presumption was in place 3 months ago. However, the close contact quarantining, you know, you don't have to go back and do that. The model notice changed just recently, so that's not necessarily a requirement, but you don't have to quarantine those in close contact. At this point, it's already, you know, already passed. So, you know, you probably don't have to go back and do anything other than maybe take the intake form and make sure you're protected that way.
I forgot my camera was on and I can't touch my face. On that question, I'll add too that from a standpoint of if the employee already had COVID, then yes, we would recommend that you still go through the same process, because none of the organizations have deemed whether they are safe from getting it again. And
Correct.
so even if they had COVID 2 months ago, they tested positive, they went through their quarantine period for that, but they were exposed again, you want to take the same precautions you would with any other employee.
Absolutely.
Next question, if employees test without reason, do they have to inform their employer?
I would say yes. You know, in the event, I mean, this is a tough one. You can't require an employee to tell you every time they go and test. However, they might have some reason. The problem is if the employee comes back positive, obviously you'd want to encourage them to have some honesty with you, because you don't want them in the workplace. And you're going to want to do your COVID intake form. You're going to want to go through the whole process with them and make sure that your other employees are safe as well. So while you can't require them, if they decide to go out and test on their own because they had some exposure, it would be nice to know. And I would hope that you'd want to build some kind of transparency with your employees so that they don't feel that they're going to be in trouble or, you know, get retaliated against in the event that they go and test. But you know, it'd be nice for them to let you know at least that there could be a potential exposure. And if an employee had a direct exposure to somebody outside of, you know, the home or a friend that tested positive, they're really supposed to exclude themselves. Unless you're in healthcare, then it's a little different situation, but something to keep in mind.
So does the 24-hour notice requirement include or exclude non-business hours like weekends when the company is closed?
If you found out on Friday and you're closed on Saturday, you better get them out Friday.
Okay.
And if you end up not finding out till Monday morning that somebody tested, you know, positive, but if you're closed over the weekend, then they shouldn't have had the exposure period of the 48 hours unless it was that Friday, then you have 24 hours that Monday to get it out. So I do it as quick as possible.
Okay. Jen, in that type of situation, if they found out on a Friday and then their 24-hour period would run over the weekend, would you recommend them emailing, texting, or calling the employees over the weekend to notify them just to be safe?
All of the above. I mean, yeah, I absolutely would. And we've done it. I've done it on the holidays, unfortunately. And like we just want to make sure that they're aware and that they know that they've had known exposure. We want to make sure that they are taken care of and that they start to quarantine as quickly as possible. We don't want any responsibility and liability coming back on the employer. So I would say the sooner the better. And I know that might be some extra hours or some extra time, but it's not overly difficult to get the notice out. It's more time consuming taking the positive intake form and understanding how the employee contracted it.
Okay, so last one. And this question I'm trying to put in the context of your presentation, but I believe it came in when you were talking about the employer requirement to have their employees tested if there's workplace exposure.
Yeah.
What if the employees refuse to get tested?
Yeah, that's a really good question. You can't require that they get tested. And it's really a challenge because some people say, I don't want to know and I don't want to get tested. You'd still exclude them from the workplace if they've had direct exposure or close contact with an employee or somebody that they know of. And if they choose not to get tested, then they're out for the 10 days. And you just keep them out of the business. I'd exclude them out.
Okay, perfect. So Jen, that is all of your questions. For those of you that have managed to hang on through the whole thing, thank you so much. We greatly appreciate your time. We know this was a lot of information. There were a lot of people on here. And so if you do have any further questions, please don't hesitate to reach out to us. We're here to help you. And then we will be getting the slides out as well. So expect that email today, tomorrow at the very latest, depending on what my inbox looks like when I check it. But we should have those out to you in the next 24 hours, 24-hour notice. So just again, don't hesitate to reach out to us. We are here to help you. We know it was a ton of information. If you have any questions, let us know. Jen, thank you so much. Your expertise is invaluable, and we will see you guys next time.
Love you guys. Hang in there.